Good morning, good afternoon to everyone who's present here with us. I'm your host, Kriti Goel from DPO Club. And to give a brief a little bit about DPO Club, I would like to say DPO Club is a practitioner led platform focused on simplifying data protection and privacy in real world business context. It brings together professionals across law, product compliance to bridge the gap between regulations and execution. Today, we are hosting a webinar on the topic of from control to consent. And the idea behind this topic is how, in practice, implementing consent is very different from what we have in written aspect, whether it's right now the different websites that we use and we have supposed to share our consent with for from checking a tick box to accept all. And the real question today isn't whether consent was taken, but whether control truly exists. I would like to introduce our speaker. Our first speaker is Aakash Jain, who brings a strong perspective at the intersection of business strategy, product scaling, and market expansion. I really welcome you, Akash. And our second speaker is Ketan, who brings insight from financial and technology ecosystem, particularly around data-driven decision making and high-stake regulatory environment. I welcome you, Ketan. And now I would like to introduce our esteemed moderator, Colonel Binoj Koshy, a seasoned leader bringing a strategic operation driven perspective to navigate governance, risk, and compliance in this complex system. To take this conversation forward and anchor it into real world application, I would like to hand it over to our moderator who will guide us through the discussion. Over to you, sir.
Thank you very much, Kriti, for that introduction. Um, the topic that we have chosen is actually quite sensitive in terms of the DPDP law that came into India and which is applicable across the country today. The very fact that this law did come up through a large amount of iterations is is a witness to what it is right now. I know the Indian corporates have were not yet in a frame of mind to accept this regime of DPDP, but yet, if you take your mind back to the February of this year, the European Union actually walked into India to do a free trade agreement with us. Now, the confidence there was actually with regard to what India had enacted this law and what it would probably provide that amount of security even to corporates that would flow into India. Now, I was part of the iteration in the when the Aadhaar Act was being challenged in the Honorable Supreme Court. And in the judgment, that is Justice Puttaswamy versus Union of India judgment, you would see that 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 became the actual legal mother of the DPDP Act. That is what we see today. We are now sitting about 4 to 5 months away from the enactment, which actually took place on 13 November 2025. The consent management framework is of most significance, and 1 year was the time for it to be implemented. That is, by 13 November 2026, this year itself, the consent part of the framework has to become effective part of the law. The law, of course, is to be effective in 18 months. That is, 13 May 2027 is the date when the law will be effective. Irrespective of the judicial review that is happening in the Honorable Supreme Court now, many of you will be aware of. In the DPO Club has also populated a page in that sense, so you can see the update of the case that is ensuing in the Honorable Supreme Court. Now, insofar as consent is concerned, it is nothing new in the Indian regime. In fact, about 10 odd sections in the Indian Contract Act of 1872 is actually devoted to the aspect of consent. Consent cannot be coerced and all. So from that standpoint, there is nothing new that India doesn't know with respect to consent. In fact, 1872 document is very explicit in terms of the consent. But In case of the DPDP law, or the Digital Personal Data Protection Law of 2023, this aspect of consent has become a white elephant, rather, I would like to term it. Because unless there is a consent, and consent is applicable across the globe, across the complete geography of Indian business and Indian services that is to be coming up. So the fundamentally, if you see in the Indian Contract Act, a consent was actually a contractual obligation. But when it came to the aspect of extending fundamental rights of an individual via Article 21 of the Indian Constitution, consent then became a very important aspect. Consent has to be explicit, consent must be informed, consent has to be specific, consent has to be limited, and it is not that old option of a tick box that did exist. There were provisions that have been added into the law where a consent can be revoked or consent can be withdrawn. So these complexities are now actually burdening the fiduciary or the corporates in India as to how it is to be implemented. So to discuss all this, we've got an esteemed panel members here. Dr. Ketan comes with a large amount of experience, and his work on from an industry perspective is quite an eye opener for me, at least on a personal front. And Akash, of course, in his own industry, has been a stalwart in bringing about privacy as a culture within organization. So I would like Dr. Ketan, if you can give a word of introduction, then I can start my question with you, please.
Sure, thank you. I hope I'm audible. So, just by way of introduction, my journey in privacy actually began more than 10 years ago. When I first started negotiating contracts for software for, large organizations, and a big part of that, because some of my clients were outside of India, was information security, data protection, and that actually interested me. So I went on and did my master's in law and digital technologies, where I also focused on privacy. And then I actually worked with the then UN Special Rapporteur on the right to privacy, Professor Joe Canataci, as part of his team while I was doing my double doctorate in data protection and identity management. So, as part of my background, I've also been involved with advising the European Parliament and the European Commission on matters of privacy and the interpretation of the law. After doing all that, I also worked as a assistant professor at the University of Malta, and then I decided, okay, academic life is too easy. Let's get into the meat of things by getting into the industry. So that's how I came back to India. I joined Deloitte, which is where I work now, on the day that the DPDP was passed. So it's been quite an interesting 2.5 years since I've been here. And yes, after that, it's just been industry. Thank you.
So wonderful. So, by virtue of your profile, I have framed a very beautiful question for you. The first question, of course, the raise of concept of consent. Will this be very simple, or will it be a complex ecosystem from an Indian regime is concerned? Can you, for the ease of understanding of the audience, differentiate the aspect of consent in the DPDP law vis-a-vis the global law, especially in particular to the GDPR, that is the European Union? So, can you throw some light for the audience on this, Dr. Ketan?
Sure, absolutely. So, in the very concept of consent is quite simple. It just means agreement, right? But the problem then comes in execution, because if you need an agreement from any individual to process their personal data, it means you also need to show that you did get their agreement. You have to show some evidence of consent. And also, one of the key requirements from my reading of the law, at least, is that the lawmakers want to make the lives of individuals simple while giving them the power to say yes or no to the way that their personal data is being processed. They don't want an individual to go and talk to 100 different people and say yes or no to them about whether their personal data should be processed. And that is why when we talk about the ecosystem of consent in India, we can't avoid talking about the consent manager, right? Which is something that is very little is known about that actually. Just because this is a very new concept. We have things like this, equivalents of this in other regimes. So, for example, if you talk about universal consent in under the CCPA, under Californian law, we also have this thing of self-sovereign identity that is coming up in the European Union. The point of all of this is quite simple: to give control to individuals, and which is why I really like the topic that has been chosen, for this webinar today, because all of this comes down to control and the ecosystem that you need to put in place to give individuals that control. So in other places, of course, the laws are quite mature. European Union has been doing this since the 50s and 60s. The GDPR is just the latest iteration of data protection laws in that region. Several other countries, Singapore, South Korea, the US to some degree. I mean, the US came up with the right to privacy in the late 1800s. So they are quite mature, which also means that the people in those places know what consent means. And they know what it means to either give control or to not give control to an organization about your personal data. But this is something that is missing currently in India. As you mentioned, the Puttasamy judgment, it was 2017, right? So it's not even been 10 years since we have this idea that we have the right to privacy. So, of course, it's difficult to also tell 1.5 billion people that they need to give consent or what it is exactly that they are giving consent to. So yes, what has happened is the ecosystem, the way the lawmakers have created it, they front-loaded the complexity. So they don't want individuals to deal with complex, choices. They don't want individuals to have to say things in 100 different places to exercise their control. They want it all to be front-loaded. So the consent manager does it all. You can think of the consent manager as a sort of central highway or like a toll plaza, because it is a what we call as a many to many system. Basically, a billion people will be accessing the services of a very small number of consent managers to reach many hundreds of organizations that might have access to their data, right? So, of course, there are pros to this. As I said, no need to reach out to 100 people, only reach out to a few that have been empaneled by the Data Protection Board. But it also means that these few almost have a sort of panopticon-like view of who has access to what. That is also something, that is a con that we will actually have to engineer away somehow. And of course, when I talk about panopticon, for those who don't know, it just means there is going to be one organization that will know exactly what every individual is doing, who they give access to, who they don't give access to, which means that if they are allowed to monetize this incredible view into a person's choices, they are probably the greatest advertisers ally that could ever exist. If they are allowed to monetize it, right? But if they are not, hopefully, then they are simply the fast tag of the world, right? Who just make sure that everything is easy to process between people and corporations.
Yeah.
So, just one last point I also wanted to make, which was about consent managers and interoperability, which I'm sure this panel will also want to talk about. I'm sure Aakash has a lot to say about this because, of course, you can't have one toll booth if you also don't have that one FASTag standard, right? And we don't have that right now. It was something that the government was saying that will come around with the Bharat Standards organization, but it's still not here. So yes, the way to implement this is going to be very, very difficult, and that is also going to complicate the ecosystem a bit. I'll pause here.
Yeah. Yeah. Thank you. Thank you, Ketan. You brought in a very academic concept of the word consent itself. Akash, you come from an industry which is more of product, and you cater to actually the significant data fiduciaries by virtue of catering to the account aggregators and those industry which is there, and for sure they will be a larger role player in the complete consent management implementation. And in fact, the very fact that these payment aggregators have got a platform in place would be actually the one that will actually flow into the consent management aspect. So in if you see the timeline of implementation, which is quite ambitious, so the consent management has to be effective by 13 November 2026, unless there is going to be a review of that. So there is a paradigm shift of the connotation of this concept from what it is actually viewed as. In the pre-DPDP regime, consent was largely a defensive legal tool, used by companies to protect themselves to what it is expected. In the new era, it is actually more of a fundamental functional reality that has come. Hence, for a consent to control, the DPDP law tends to perform capturing the paradigm shift from the old regime to the present new active sovereignty, what Ketan was mentioning to us. Uh, Now, I want to really know how will this nuance of shift from a more from a a literature effect to the functional reality will take place if corporates were to adopt this new concept. Ketan?
Yeah,
Sorry,
yeah.
apologies. I think
I'll take this.
Akash.
Yeah, I'll
Yeah,
take this.
yeah. Please,
So
sorry.
yeah, thanks for inviting me to this. Like, I think with you and Ketan being on the panel, like it's a honor to be here. With going to the question, so let's say like earlier, what companies used to do, like they used to have this consent in some terms and conditions, going to store or hide it somewhere so that users do not see it. And with DPDP, this is exactly what is changing. Now, with DPDP, we want users to see what they're giving the consent for. The government wants the users to see what is this consent for, what's the purpose for this consent, and how long this data will be stored, and how it will be used. So all these aspects is something that companies will have to cater into. Now, I have been in account aggregator, which itself is a consent manager for financial data. So here we currently store all this information, and with all this information, let's say what is the purpose, what is the data that's going to be used for, and how long this data will be valid. Now companies will also have to provide a mechanism to revoke a consent. That means if data is given, the user should be able to revoke the consent, and ultimately all the times downstream applications should also be able to revoke the consent on that basis. Now this doesn't become just a problem of consent for the companies. Let's say I'll give example of lending clients that we have. For them it will become very essential to show to the user that why they're taking data. Let's say if they take data for KYC, they can only use it for KYC, so they should have explicitly gotten another consent for using the same data for marketing. They should have explicitly gotten a consent to use this data for any other purpose for that sake. So that is something that will become complex for companies, but for the users, it will become a really beneficial point so that they have control over all their data. Now, companies will have to design the journeys in such a way that it doesn't cause friction in the user journey, but also it takes the consent of the users in all the data that they process. So this is going to be challenging for the companies, but yeah, we have the entire templates ready, and the company should be able to use it effectively to give a consent and take a consent from the user, and then absolutely use that data. So so the consent is moving from companies to the users. So that's what my closing point would be. Sir, you're
Maybe
not
on
audible.
mute.
Yeah, yeah.
Yeah, thank you very much for that clarity, Akash. Now you are day in and day out involved with the aggregators, so there is a large amount of consent already existing as a practice there. Okay, Dr. Ketan, I would like to come to you. The law is very clear. It talks about notice prior to taking the consent. Now, this notice has become a big burden in terms of its implementation in the corporates as of now. Notice has to precede the consent that we are all aware as per the bill. Presuming that there will be an inherent latency and there is a rigid adaptation that will happen by virtue of this notice, What do you think is the burdens that the corporates will be encountered with? Also, looking at one more aspect of consent fatigue that may set in by virtue of making consent as the core implementable aspect with respect to the third most important aspect is the language barrier that is coming in. Now, earlier, I could just make an English notice and allow a tick, but that was not going to be any more valid now. India has got about 200 to 300 odd languages. In fact, there are dialects that is not doesn't even have a script. So, in these challenges, how do you think this concept of notice preceding the consent is going to be implemented by India?
So that's a great point. And of course, this jumps on the back of our previous question on consent, which is if consent means agreement, of course, it's important for people to know what it is they're agreeing to. And they can't agree before they know what it is they're agreeing to, right? So, of course, notice has to precede consent. And that's all the notice is. It's just letting people know what it is that is going to be done with their personal data, what data is being collected, and how can they actually do something about it. Access what data they might have, delete what data they might not like the company to have, etc., etc. So, honestly, the notice thing is not really, I wouldn't call this a paradox. It is inherent in the idea of consent. If you want users to give consent, you have to tell them what they are giving consent, right? But of course, as you mentioned, when we actually implement this, what does it really mean? And it is something that companies are really struggling with because, as Colonel Koshy, you mentioned before, we did have consent before. I mean, we've had it since the Contract Act. In fact, the IT Act, SPDI rules also have consent in them. But the fact of the matter is, none of them talked about notice, which was a big lacuna in the law. Basically, companies were being asked to take consent, but were not being ordered to tell people what they are giving consent to. So this is lacking in the ecosystem because it was something Indian companies just didn't need to have to do before. There are ways to solve this. Of course, there are consent tools in place, and of course, you can just have a privacy notice on your website. So you have to do something. It's not something you can move away from because, again, for mine and my colleagues' reading of the law, the control that individuals have is important, which means the idea of giving notice to them will never go away. And in fact, I expect that the Data Protection Board, whenever any investigations happen, will hold for the individual if the individual says, hey, I couldn't understand what I was giving consent to. Right. So how do we make this possible? Which was the second point you talked about, I think, which was languages. And also the granularity with which you might have to give consent. Now, there are other ways that people have solved this. You can see, for example, in the European Union, they have something called the layered approach, where the EDPB, the European Data Protection Board, says that you can have large areas that you have to give notice for, and then you give the granular details later on. So you can actually make it a choice for individuals to know what is really important for them to know, and then the things that they can actually get into the details of if they choose to do so. It won't materially make a difference in what they understand of how their data is going to be used, but it's still control that is given to individuals, right? And then the other solution that you typically see is something like Apple's nutrition label thing that they did for privacy notices, where they required any app on their app store to actually have a symbol for each statement, right? It wasn't English language. It was actually a statement showing this is what's going to happen to your data. This is where it's going to go, etc. So, of course, symbolism is something that we can really do in a country like India. I feel like that might just be the way to go forward. Some standard set of symbols, the way we have road signs, right? Road signs are a very good parallel because they give you a lot of information in a very condensed manner. So that might be something we have to do instead of going for the 22 languages, in the constitution, or the 200, 300, even the thousands of dialects that we have. This is a very, very India problem, right? No other country really has a problem of people speaking so many languages. So
Yeah.
really, the only way to solve that, I feel, is iconography of some kind. That might really solve it. But I mean, as I mentioned before, you can't get away from giving a notice. All
Yeah.
you can do is make sure to share it. Now actually, that reminds me, just recently there was a court case in the UK where they held that companies don't need to prove what was in the mind of the individual when they were giving consent, right? And this might be something that Indian companies can really take on. You don't have to assume that you're that or know what is going on in the minds of the people giving consent. You need to take a reasonable precaution, give them enough that they understand, get them to click on some sort of agree button, and then just take that on face value. And of course, with some complications arising from the data of children or persons with disabilities, which
Right.
is where again iconography may help. I'm not sure, but that also is accessibility is a big issue.
Absolutely.
That's
Right.
where I would want to end. I'm sure Akash will also have things to say on this.
Yeah. Akash, you're day in and day out interacting with these your companies, which you are servicing. Now, two aspects. One, probably what Ketan gave out is the fact that when they come to a portal or an app, the app or the portal is agnostic of the language that they know. And the unfortunate part in the law is that unless the notice is understandable, the consent flow doesn't exist. That is number one. Also, for the fact that any industry in India have a chain of third-party vendors. So a consent withdrawn at one stage or at a chain will have to be carried forward to the others in the chain. So, in this, there is a difficulty in terms of seeing the practicality. Firstly, is the itemization of this notice. Of course, that can still be achieved, but how do you build a consent kill switch across the complete supply chain that is truly adoptable or implementable in the Indian regime?
Yeah. So first I will talk about the itemization problem. Let me speak about like how so today in the account aggregator ecosystem, most of the journeys are in English. We don't have like much of the journeys in native languages or India specific any of the languages, and that means we are catering to just a portion of Indians and not all. Or if we are so that is something that we are also thinking in the ecosystem, whether to make it like in different languages so that users across the country can understand. Someone who doesn't understand English can also understand what they're giving the consent for. Now we also have, during the journey, we have the consent parameters on the screen, but let me think of someone who doesn't know English, so they will still give consent without knowing what they're giving the consent for. So that is something that we are trying to solve in the account aggregator ecosystem as well with several languages. But there was a very good point mentioned by Ketan on like some notations that could be better. The road signals, that would be a better option. But then that also has to be universalized, so everyone should understand what it means. So that is something that we would also try to do. Currently, it's just in English, and since children's accounts are still not available in the account aggregator ecosystem, we did not face that problem. The other problem with PWTs is something that we are solving as an ecosystem. We don't have a framework for it right now. But we are solving for it with a nominee thing. So someone who is a nominee for the PWT will be able to approve consent on their behalf. They have to spell it to them and also have the UI with different, like different provisions for them to understand what's the consent for. So that is how we are trying to solve. Coming to the second thing about the kill switch, let's say like a user has revoked the consent and he doesn't want his data to get processed further. But then how do we communicate to vendors? So this is a problem which we are already solving in account aggregator ecosystem as well, but
Absolutely.
not at like multi-layer support. So we don't have multi-layer thing how we have in the DPDP. We just inform the financial information user that this guy has revoked the consent, Now you have to stop using the data that you have processed for this user, and further data also you should not fetch it. In case of
Yeah,
periodic concerns, you should not fetch further data. A
yeah. But
similar
sorry
approach
to
will,
sorry to
yeah,
butt in here. It's easy
huh,
on a very practical note, but in terms of technology, how would you, how, if you can throw some light on how you are
yeah,
doing
yeah,
it in the aggregator regime, so that the
yeah,
participants can learn out of it. Yeah.
yeah. So the user can give a revocation, do a revocation on the mobile application as well as the CAMS Finsel, our website. Now there's downstream notifications that travel. So once the user gives a revocation request, immediately we send a notification to all the downstream applications or downstream data processors that okay, this guy a notification as such, a API call to them or a webhook notification to them that sends to them information that this consent has been revoked. Now when they receive this notification, they have to immediately have a mechanism to stop utilizing that data. So a similar architecture should be followed here as well, where on each there will be like technical notification that could travel from one participant to the other, where like the consent managers will notify the ecosystem that you have to remove the user. Now comes the vendor problem. The vendor problem is someone who is not the user but who is analyzing the data that they have. So now the vendors also might have some such consent information. Similar approach, event driven approach, where such a event is notified to all the ecosystem participants, and one by one they revoke the consent for it. And so that is how I think we are doing at the AA ecosystem, and that's how it should be propagated in the DPDP as well.
Okay. Thank you very much, Aakash. You really addressed that issue, which is more of a touchy subject for the corporates. Dr. Ketan, by virtue of your global experience, and I'm very sure that what Akash mentioned now has been in practice, or there are best practices available in the GDPR regime, because we look at GDPR as more mature model and covering a larger mass than probably the federal laws like the CCPA or the Californian or the other type of laws which is applicable in the US. Now, one of the most important aspects in our law is the power of withdrawal. And in the Indian Contract Act, withdrawal of consent was actually conditional in nature. But here, the withdrawal of consent is a blanket right transferred as if the Article 21's powers are being, percolated down to the citizens of India or to the data principal per se, as we call it. Now, how does a company ensure that the withdrawal triggers a real time kill switch across all downstream processes and even up to the third party vendors, especially the aspect when it has to be technically incorporated within the processing aspect of the corporates? So, how do you feel? How do you think that this will be addressed by the corporates in its true sense?
Sure. So let me first tackle this from the legal nuance point of view, and then we'll talk about the technical side. So from a legal nuance point of view, one of the key distinctions between the DPDPA and, let's say, a law like the GDPR is the GDPR actually has contract as a legal basis for processing of personal data. So a company can say, hey, you agreed to this in a contract. You can't just say that you don't want it anymore unless it's written in the contract of how you can terminate it. But in the DPDPA, there are only two legal bases, right? There's just consent and there's legitimate use. Even under legitimate use, really there is nothing contractual in place. It could either be about somebody voluntarily giving their data, or if it is to follow the law, or for medical emergencies, or for employment purposes, right? Those are the big ones. What that basically means is that under Indian law, the DPDPA has taken the center stage that it hasn't taken in other laws. So in the GDPR, it is just one of 6 legal bases that you can use. But in India, it is one of only 2. And given the way the law is written, it is obvious that all of this, again, goes back to the topic that we are discussing here. It's all about control. It's about giving the individual control, right? But of course, there are a couple of caveats. One, it might be a blanket right to withdraw consent, but it is not an absolute right to have your data deleted on the backend, right? Your data might still be needed for legitimate users, which might be, following the law, or it might be for medical reasons or something else. So you can say no. You can say, "Oh, I don't want you to process my data for this anymore." But you can't say, "Hey, no matter what, just delete my data." Organizations are not required to follow that, assuming that they have a legal basis to keep that data. So that's the legal nuance. Yes, it is a blanket right, but it is not an absolute right. So at least that way we have some measure of control.
Perfect, perfect. And
Now,
legitimate use by virtue of powers of use by the government. These are of course existing.
or
But
employment. And actually, one of the key things that the Indian law has done is actually it's called out employment as a legal basis. This is not really there in most other laws. So, in some ways, this is very friendly for organizations because they can just say, "Hey, this was for employment," and so there's no consent required of you for me as an organization to process your data for employment purposes. Right?
Mhm.
So,
But here, I would like to ask you a specific question.
mhm.
How is this aspect which you mentioned right now on real time being implemented or being incorporated in the complete business process of an enterprise? How will
Yeah.
that happen?
So this is actually where this might be quite different from account aggregators. I was listening to Aakash talking about it, and I was realizing just how different the world is outside of account aggregators. Because in most organizations, there is no vendor whose access has to be revoked. Right? Your vendors are going to be your cloud service providers. They are going to be your background checks, verifications for HR people. They're going to be, SaaS tool services. The vendors, or even in, for example, manufacturing places, they might be, extra people that you employ from contractors, right? Or they might be just people who sit in the cafeteria who have a list of all the employees because they want to know how many people they are giving food to. It's a very, very different ecosystem, very technically immature, if I may say so, because you might have, as a large organization, you might have 500 to 10,000 different vendors who are doing everything for you, right? And how do you make sure that there is some real time kill switch that percolates this consent or withdrawal of consent to all of these different vendors? The fact is, this is just legal fiction, right? In very clear terms, this is not really possible. There's no way for one withdrawal of consent to immediately percolate down in milliseconds or even in a few hours, even if all of your ecosystems, your technical ecosystems are very, very well connected. And most of the times they are not, right? Most of the times they are not API calls. Most of the times you are sending Excel sheets to vendors in India.
Thank
So,
you, Ketan. I think you actually sensitize the DPO community and the privacy offices of these. I have one final question to Akash. Probably then we can throw the. I've got large amount of questions being populated. So my last question to Akash, probably here he would be able to throw some light. In the Indian regime, the law has opened up for a third-party consent management organization. Hence, there is a leeway where fiduciary can designate a consent manager external to that organization to do the management of consent as deemed fit in the DPDP law. Now, let us say that I, as a fiduciary, I hire a consent manager and there is a breach or a compromise. Now, if you look at the centralized control aspects, this whole thing has been compromised if the consent manager platform itself is compromised. So, this is my first question. In this case, what should the corporates do to ensure this safety? I'll add my second question also. There is a concept of interoperability, which Dr. Ketan was also mentioning. Now, in the case of interoperability of these consent. And let's say a person logs into the consent management portal and withdraws his consent because he finds that this consent manager is giving services to five more different companies. In that case, how should fiduciaries ensure that the integrity of consent management and the services thereof is maintained? I know I've asked a very complex question, but
Yeah. So the first question regarding breach, so like in today's context, if like breach happens, it happens to an organization itself, and the data is specific to that organization gets breached. But now when we talk about consent manager, which is an entity which provides like
and
services to
mind you,
various
Akash,
fiduciaries.
in the definition, a
Uh,
consent manager is also a fiduciary by the DPDP board. Remember
okay.
that. Yeah.
Yeah. So now, okay. So now when we go about like let's say consent manager, which itself is serving so many other organizations on handling their concerns, and if that get compromised, it's a very difficult and it's a very significant breach. It can also be breached, and then also we can also have a thing such as like this consent manager itself is compromised, whatever situation arises, where it's favoring some of the organizations. Like Ketan spoke about, it has a lot of data, it has insights, the metadata, which itself is lot, worth a lot. So what happens in that case? So to prevent, like how can we prevent it? Like how do we do it right now in the account aggregator ecosystem? Now, what we do, we have tokenized access. We have regulatory audits. We have internal regulatory audits as well as we have external audits, and then we have audits by RBI itself. So this audits makes it's very like difficult for any consent manager to be compromised or like data. It has certain rules regarding how do you store the data, how do you encrypt the data that you are storing. So all these mechanisms will be required to put in to make sure that the breach doesn't happen. And in case anything of such happens, the consent manager itself should immediately notify all the fiduciaries whose data it is storing, and it has to notify all the users also within some stipulated time that this data of yours got breached. So that is the first thing that you have to do. In that case, something kind of that happens. But yeah, prevention is the best thing that we can do here. And with account aggregator also, we are doing the same. We have encryption mechanism. We have tokens from various entities. And then, yeah, that makes sure that, and we also have audits, a lot of audits. So all the traces of the consent, we keep it for eternity. So that means it's always traceable which consent went where, when it was revoked, and when the data was fetched. So similar aspects should be put in here also. Regular auditing should help.
Yeah. Coming back to the second aspect, the interoperability part. Now, I log in and I find that my ex consent manager is also managing five other services which I am part of. Now I take an advantage of withdrawing my consent. Let's say on my marriage anniversary date, which I have populated in five
Hmm.
places. uh, how will this work practically in the corporate world? Now, does this mean that I've withdrawn consent so it will be applicable to the other five companies or the services that I see, or the fiduciary has the right to exclusively maintain that consent management, agreement with that particular
Yeah.
entity?
So now this I see like all the five consents are individual consents and not connected at all. So the same data, but five individual consents. So user should be able to revoke consent for one particular fiduciary at a time. So when he revokes the marriage data or the information regarding his marriage date for one fiduciary, it should not like itself revoke it for all the others, because that all of these are separate consents by itself. So that is a mechanism that I feel should be adopted, and that's what it will be adopted as well. And that's the same thing that we do at account aggregator as well. So same thing happens.
Mhm.
We have the same data, the same financial bank data, sharing to five different users, like financial information users, and each consent is separate. Each are the unique consent. So if the revocation happens for one consent, it does not explicitly means that you have to revoke the data for others as well. A similar
Okay.
approach will work here.
Yeah, okay. Dr. Ketan, can you throw in some light into this aspect which was mentioned by Akash in the last sentence of his?
Um,
Keeping in mind the interoperability aspect.
I feel like again the answer
Yeah.
is going to be standards. Uh, we just need some sort of standard that makes this happen. because I really like the idea of a consent manager essentially being an account aggregator. But then account aggregators work on the basis of a lot of interoperable standards. Maybe if we can have something like that in the consent management space, and that will also reduce the risk of being a consent manager. I mean, can you imagine the risk that an organization is taking by becoming a consent manager if there is no interoperable standard? Because as you said, it's a fiduciary. What happens if something goes wrong? So yeah, I mean, maybe one of the big ones can actually create their own standard, and it can be a sort of voluntary ISO sort of empanelment where all of these consent managers work together to come up with a standard that makes everything interoperable.
Yeah, or it can be a notification that can Ministry of IT can bring out.
Yes, hopefully that.
I would. So I just wanted to put in one point out here. So we,
Yeah,
as account aggregator, we also have a body called Sahamati, which is an like on which is on the way to become an SRO. So what it does is it publishes templates for fair users, and it like makes sure that we have a common platform where all the account aggregator in the country, 16 of them, join and discuss on things. And I think some sort of ecosystem partner should be there which manages all the consent managers in the country.
yeah, okay, right. Thank you very much for this wonderful insight. We've got questions. Kirti, you can probably populate these questions on the screen, and then I will assign it to the speakers, please.
Yes, sir. I have shown the questions on the stream.
No, but then can you populate one question at a
Sure,
time?
sir.
Is it
Sure, sir.
possible?
I can populate the question.
Yeah, that's wonderful. That's wonderful. I
So
think
the first question that we have is, what will happen to the data that has already been collected once the DPDP comes into force from May 2027? I'm showing that question as well. Is it appearing?
yeah. Please show one.
Yes, is it appearing?
Yeah, yeah, it's come. Yeah, correct. What will happen to the data that has already been collected once DPDP comes into force from May 2027? I think Akash, you can take on this question, please.
So as per my understanding
Uh,
of hello, I'll just take this. So
yeah,
as per my
please.
understanding of the DPDP regulations, whatever data has already been processed, even for them, we need to have a consent mechanism, uh,
Yeah.
and that has to be in place, and that is what will be done here. So all the data which have been collected earlier, a consent will be put in place for that, and we have a consent manager platforms, different consent manager platforms that are working on a solution for this. How do you enable this?
Yeah. In fact, I would like to give a use case here. Recently, if one would log into the Air India website and do a booking, they populate a refreshed consent taking an ecosystem first, and then only then they allow you to. So it is you would literally say that consent is applicable in retrospect, number one, but as and when the customer comes up, one can revoke that aspect rather than contacting each one. It may not be practical when you have a large data set to be managed. Yeah, can we have the next question, Kirti? Yeah. So the next question is how to collect individual consent in large meetings. I think Dr. Ketan, you can take on this. You might have handled this also as a scenario.
So, as a matter of fact, in my previous life, when I was an academic, when we used to go to conferences, especially those with a lot of people there, you would literally get handed a sheet, a consent form that you would then say, yes, I agree to my data being used for this. And also that, my pictures can be taken or posted on social media. So, um, of course, that is a very paper analog based thing to do. But I feel like this is something that any platform will also be able to do. I mean, if you're doing it on Teams or Zoom or something, you're having a large meeting. I think these tools will also need to have some sort of functionality where you collect consent from them before somebody even joins the meeting. But of course, if we are talking about in-person meetings, then it's going to be an interesting problem to solve. Maybe a QR code, right at the entrance that lets somebody look at the notice and give consent. But it'll have to happen. I mean, if you're going to collect consent, you'll have to give them notice. You'll have to collect the consent and show evidence of it somehow.
Yeah. To make the scenario a little lighter, I did attend a wedding in Gurgaon recently, of a lawyer. So, by virtue of the present law coming in, he actually had an innovative idea of placing a notice at the entrance of the marriage, hall, saying that I'm going to record your video and this is only for entertainment and I'll delete it subsequently. It's such a, I mean, we'll have to think differently now. And Rohit, I think your question is quite vital, but there is a lot of unlearning and learning that India has to do. And I think we all have a role to play when implementing his law and making it a success. In fact, Rohit, it's not only you and me, it is the whole world watching as to how India is going to implement this law. So let's make it a success, probably. That's my last word. Yeah. Next question, please. Okay. We have a question here. Should consent manager be a system or an individual? I think I give this to Dr. Ketan. He would be a better person to give us an insight into this. Yeah.
It has to be an organization, because if you have to be a consent manager, you need to be empaneled by the board. And one of the key requirements in the DPDP rules is that you have to be an organization with a certain amount of paid up capital. There are lots of requirements to meet before you can be empaneled.
Yeah, correct. Thank you. Can we have the next question? Yeah. The question is, the corporates are taking consent for different initiatives, collecting PII. Does it mean they need to give notice every time, or one privacy notice in the website explains the purpose in general? I think, Aakash, you can take on this question, please.
Yeah.
Very interesting question. Yeah.
Yes. This is So, like out here, I'll talk about a multi-consent concept. That's something that we also have. So we have different purposes. If your website wants to take for different purposes, all the purposes can be mentioned on the same today. Yeah, but each of these consent will be separate. Now, for each different data, each of consent will be separate. But the journey, from a product perspective, the journey will be one where you will see all the consents in the same journey and give consent for. So that is something that will happen. But yeah, each consent individually are different when you take different data.
Just to put a practical flavor on this, maybe some companies may not want to put all their purposes together in the same place because it seems scary to a user that, oh, you're going to use my data for 10 different things, when in fact it's only going to be for one thing, if, depending on the services that they sign up for. So this is very much a business understanding thing also.
Yeah. So I would like to give a little different perspective here from what our speakers have spoken. If you read the definition and the underlining meaning intended by Section 6 of the DPDP law, it's very clear that it has to be in silo. A purpose cannot be a blanket purpose. Secondly, for the purpose is what is driving the consent and that field of data that is being collected. So there is going to be a difficulty in implementation, but yes, thank you for this question. It has to be enforced upon for implementation to keep consent directly associated with the PII that is being collected and for the purpose which is collected. So that is the beauty of this law. Yeah, thank you. Can we have the next question, please? Yeah, we have Tanushri's question. What about the data related to children? Yeah, we didn't want to specifically step on this, primarily because it's a topic by itself. So we plan at DPO Club to host a webinar on this particular thing. Okay, in any case, you've asked, so we will take up this. Will any age specific will be done? Also, in case of a data breach related to children, how will be the notice be served, and to whom? Okay, I'll take on this question for you. Firstly, in the case of children, the routine consent framework is not applicable. There it is verifiable parental consent.